Hello and welcome to Bangalore International Centre's very own podcast, BIC Talks. Bangalore International Centre is a platform for informed conversations, exchange of ideas, and a space for arts and culture. BIC Talks brings the essence of all that the physical space stands for and more to your doorstep.
Hi, I'm Pawan Srinath and welcome to BIC Talks. The US-India relationship is not led by its governments or by grand defense and strategic concerns, but by its people. It is the movement of people between India and the United States, especially Indians going to the US for study, work, and even settling down and becoming citizens, that has been the bedrock of shared prosperity. All of this has been under threat these past few years and only exacerbated by the COVID-19 pandemic and by the Trump administration's continuing visa bans and restrictions. How can Indian workers, students, and families navigate this maze of changing visa regulations? Noted immigration attorney Sheela Murthy joins us from Maryland and talks to strategic HR advisor Hema Ravichandar in Bangalore. Tune in not just to understand the recent changes, but also learn what options are open for you if your future in the United States feels uncertain. Over to Hema for the remainder of the episode.
Sheela, I really can't get the excitement out of my voice. So happy talking to you after so many years and reconnecting. So it's really lovely to speak with you, especially on this topic, which is so important to so many professionals, Indians, family members, etc. And I know that you are doing tremendous work in this area through the Murthy Law Firm and all the immigration work that you do. To our audiences, Sheela Murthy is headquartered in Maryland, USA, and founder of the Murthy Law Firm, which specializes in immigration cases. Sheela, before we start and go into the throes of the issue, for the benefit of everyone, could you just give us a landscape of both the immigrant and the non-immigrant visas?
Sure. Thank you so much, Hema. It is very exciting to reconnect with you as well and with all of your audience to share some background and information on what's happening in the world of U.S. immigration law. So very, very broadly to paint the brush, of course, you have in the United States, which is the most complex immigration system in the world, you have a whole category of non-immigrant visas. We refer to them as the alphabet soup. From A visa, B, C, D, E goes on all the way through the U and the V visas. And then you have the immigrant category. In the immigrants, you have family-based immigration where, a spouse can apply, parents, citizens who can apply, etc. Green card holders have some restrictions, but they can apply. So there's family immigration. Then there's employment-based immigration where the employer can sponsor you for a permanent green card or immigrant status. And in that, you have the EB1, the employment-based first preference, second preference, EB2, EB3, EB4, and EB5, different categories from those who have got Nobel Prize or extraordinary ability achievements, to master's degree holders, to bachelor's degree holders, to special immigrants like ministers and church officials, or what we call special immigrants, EB4. And then EB5, of course, the investor visa category, where people who invest a minimum of, now the amounts have increased, 1.9 million and help to create 10 full-time US jobs, can get a US green card. And then, of course, you have the outlying issues like asylum, withholding of removal for the green card. But those are so much smaller percentage and not what our audience, I'm guessing, wants us to focus on today.
I didn't know EB5 had gone up to $1.9 million. That's quite a steep increase in any case. So essentially the orders that President Trump issued in June end, 22nd and 29th, I think. What does that order essentially say? And which of these visa categories does it really impact, Sheela?
So when the president passed his proclamation on June 22nd of 2020, then he made it very clear in the beginning of the proclamation that this was the follow-up that they had said they would most likely address, because the first one on April 22nd dealt with immigrant visas. And he said within 60 days, we'll be looking at sort of attacking, if you will, approaching the non-immigrant categories, in quotes, to save American jobs and to help the US economy at this horrible time of COVID-19. So in my opinion, obviously, he's used the global health pandemic to approach a more political agenda and to rouse his political base. The categories that have been specifically impacted are the H-1B, which most of us are familiar with, which is for a specialty occupation, generally those who have at least a bachelor's degree or higher, and the job duties are complex enough that the bachelor's degree education is required in order to perform those job duties. The H-2B workers, who are the seasonal temporary non-immigrant workers. Again, most Indians don't tend to take that option with the H-2B. Then you have the J-1, who are the international scholars and certain internship jobs, etc., who are impacted, but medical doctors are not impacted, even though most medical doctors are on J-1. And the last is, of course, the L-1, which I'm sure many of you, and you in particular, Hema, would be familiar with, which is the Intra-Company Transferee, where you send people between a brand subsidiary, affiliate, or joint ventures between the United States company and the foreign company to send people to work as specialized knowledge workers.
So both the L1A and the L1B, the managerial and the non-managerial?
That is correct. Both categories are impacted and all of their dependents. So the H4 dependents, the L2 dependents, the J2 dependents are all included in this big swath where the president pretty much says that if you are outside of the United States or not in the United States as of the effective date of the proclamation, so even though the proclamation was issued on June 22nd, the effective date was June 24th. So as of that effective date, anybody who is not in the United States will be impacted. Anybody who's in the United States should be exempt. The ban, and basically the ban, if you will, it's another version of the travel ban. This presidential proclamation or executive order pretty much explicitly says that you cannot travel back and re-enter the United States, but then there are exceptions to it. And the exceptions are if you already have a visa stamp. So if you had the H4 or H1B visa from before, then you're not prohibited. You're allowed to re-enter back into the United States. And initially, the June 22nd just said if you had any non-immigrant visa, then you are allowed to re-enter. Then on a week later, on June 29th, 2020, they issued an amendment to the proclamation saying, well, we don't mean any non-immigrant visa status. We're saying specifically if you had the particular, for example, if you had an H-1B visa and you want to enter an H-1B status, then we're going to allow you. Otherwise, we think that you shouldn't be entering, or, the ban applies to you.
Okay. So say you had a H-1B visa, and just let's stay with that. Say you had a H-1B visa, which was valid for, say, the next 2 years, but you had to have it stamped for that validity to really, be valid. Would that have the ban?
So if you have an H-1B visa stamp in your passport that is valid, let's say for only one of the 2 years because you got it based on a prior employer's H-1B approval, then you have no problem. You are allowed to re-enter the United States showing the old visa stamp in your passport, the old H-1B visa stamp with employer A. Now you're working with employer B, let's say. You can come in, and when you enter the United States, you have to show the CBP. The CBP is the U.S. Customs and Border Protection, those men and women that as we get off our international flights, you would show them that the old visa stamp with employer A, you would show your H-1B petition with employer B and ensure that the I-94 card that is issued to you, now it is online, it's no longer a paper I-94 as some of the listeners will know, as in the past. Basically, you should insist or ensure that the I-94 matches the latest H-1B approval notice date for you to enter safely and continue to work for the entire 2-year time frame.
But if you had to come back and get your visa stamped, that would be a ban, right?
Correct. So if your visa has already expired, now you have a major problem to re-enter because your visa is expired. On the other hand, I know several people who go back when they still have maybe 3 months left on the visa. They fly back with the idea that they'll apply, they'll go spend a month or two with their family or do some work in India.
Or even get married, maybe.
Or even get married, which is, as you know, fairly common. You're absolutely right. These are young men and women of eligible married, age. And so when they come back, if they have the visa stamp left, say, validity remaining even for a month, but they have the new H-1 petition approval showing the 2-year approval notice, they should be allowed to enter and get the I-94 for the entire 2-year time frame. The spouse, on the other hand, is going to be out of luck at least till December 31st, 2020, which is when the travel ban, this proclamation, is supposed to expire, though there is a clause in the presidential proclamation that they can extend or amend it if they feel the need to do so.
And the same applies to L?
Exact same issue applies to L in terms of entry and exit and all of that. Where I think that there are possible potential opportunities for lawsuits is, since the whole and the only reason for the issuance of the executive order or the presidential proclamation was to save American jobs during this horrendous economic downturn caused by COVID-19, and this is considered an emergency proclamation to sort of quasi shut down the US borders. What the issue is, like this person who's now newly getting married, the H-4 spouse isn't allowed to apply for an EAD card. Let's say in this example, the person did not have a permanent I-140 approval, so the spouse cannot get the EAD. So now you're preventing families from rejoining or being with each other under the guise of protecting American jobs when nobody's taking away a single job. So that's what is convincing people that this is more of a political gamesmanship rather than reality, because the percentage of people impacted is so small, yet it's so devastating and overwhelming for those families who have unfortunately been caught up in this really a nightmare situation for them and their families.
So this legal loophole, probably a very good lever for the H4s, but will it also apply to the L2s? Because technically I thought the L2s were eligible to work.
Correct. So the L2s can come in and get the EAD to work, the employment authorization document, to enter the United States to work. So it'll be harder to say there is no way, no how on earth that they would ever take away a job from a US worker, from a United States worker. So I think for the L2s, it's harder. And J2s also are allowed to apply for the EAD card, but there are certain restrictions. You have to show that they are not relying on the income of the J2 to support the family, unlike for the L2 or the H4 EAD eligible people who don't have that restriction like the J2 EADs have.
What would be the kind of ideal scenario? For example, there is a H1B, while he or she has the 6-year period for the H1 validity. It's 6 years, right, Sheela?
It's 6 total, but you only get 3 years at one time.
Yeah. So say he or she is at 3 and he has another 2 months left to go, and it's going to end well before October. What should they do? Should they travel out, stay within the US, remain out of status? I don't know how long out of status is.
So the USCIS rules haven't changed. So all the people who are in the United States are freely and legally eligible to file extensions without any problem. The over 100,000 people, majority of whom are overwhelmingly Indian nationals under the H-1B program, they're all going to be legally permitted to file US H-1B extensions with the USCIS, and they can continue to legally work either by filing an extension with the same employer, or even if they change jobs or change employers, they are eligible and allowed to file in H-1B, use the portability provisions. They don't have to wait for it to get approved. They can file it, continue to work. And in fact, if you change jobs and employers, you don't have the 240-day limit, the approximate 8-month limit in filing the extension with the same employer for the same worker. So you're, in a funny way, better off jumping ship, changing jobs, and then having the new employer, because then even if the USCIS, because there are talk yesterday or day before in the last day or two that because of funding, the USCIS is planning to furlough between, I think, 50% or 70% of their employees. Again, we don't know if these are tricks and games by the administration, because the amount of money they collect on fees is absolutely outrageous. There's no connection between the cost of living index or COLA and the fee increases, which are, probably on an average of, 50 to 100% higher than COLA increases. And yet the quality of service keeps going down and down and down. If it was a private business, if it was you and I running it, Hema, we would have shut it down a long time ago.
So it's best to stay within the states and file for the extension rather than, going anywhere, even Canada or out of the country or anything. Just stay there and extend it. It's legally okay, right?
That is correct. And there is a legal loophole that actually exists because the Customs and Border Protection in the past few days, a few days after the president passed the proclamation, the original proclamation on June 22nd, actually came out with two clarifications saying Canadians and Canadian citizens who are eligible under the then NAFTA, the North American Free Trade Agreement, which from July 1st is now called the USMCA, the US-Mexico-Canada Agreement, that all those people are visa exempt and hence they are allowed to go and return back without applying for a visa and can come back and work on H-1B, H-2B, J-1 or L-1 without any problems. And there's another issue, something called the automatic visa revalidation rule that more than 90% of people, even lawyers, unfortunately, immigration lawyers may not be aware of or suggesting or recommending to their clients, where if you've fallen out of status for any reason, rather than flying back to India or your home country and getting stuck there for months, you might be able to make a trip, fly, let's say fly because land borders are shut because of COVID-19 between the United States, Mexico, and Canada. You could actually fly the person over to Canada for a few days, and there may be a 14-day quarantine, by the way, for COVID-19, but they could actually come back without applying for a visa under what's called the AVR rule, the automatic visa revalidation rule, because any trip to contiguous territories for 30 days or less than 30 days enjoys a wonderful, it's almost like a magical exemption to allow you to come back. Again, most people are either not aware of it or get very confused by this rule. And that's why it's important to ensure that you...
No, I think let's just visit that one again, Sheela. So there are two options. One option is you stay within the states and file it with the USCIS. The other option is you go to these contiguous countries, and whether it's quarantine or otherwise, and get the stamping done there. Are these two different options?
Yeah, so there's no stamping. You would never go for stamping because if you go for stamping, then you cannot re-enter the United States if your visa stamp is denied. So those who are maintaining status should absolutely just stay in the US, file the extension. I know if you're missing your parents, your family, even if it's your own marriage, I know in India, it's a big deal in certain cultures, like Asian cultures, like in India. I think it's a good, hopefully a rational explanation to say why I cannot jeopardize my life and livelihood by traveling at this time. So that I would do. It's only for those who are either out of status or have some very complex issues where they could be triggering the 3 or 10-year bars. They might want to look at possibly considering the AVR option. So I think we're getting a little bit in the weeds. I don't know that I want to. It's probably applicable to a much, much smaller, very small percentage, but it's a really, really good option for those who feel they're stuck and have no other option.
So just to summarize, if somebody has 3-year visa and the 3-year is coming to an end, he or she stays within the US and applies for an extension through the USCIS. That's the best option, right?
Absolutely correct.
So what about the student visas then? How does this affect the student visa holders who are currently on OPT?
So again, it's very similar to the H-1Bs filing the extension. So if you're in the United States on the F-1, either the 12-month optional practical training or the additional 24 months STEM, the science, technology, engineering, math, the STEM OPT extension, then you could again do all of that filing and the extensions with the USCIS with no problems. And more important, the presidential proclamation or travel ban does not apply to them. So whenever the consulate finally reopen after all of these COVID-19 closures, the F1 students are technically eligible and allowed to apply for F1 visa stamp in their passport in order to be able to re-enter the United States to pursue their education. Because, of course, the president's very clever. He's probably succumbed to the pressure from universities because they know that so many of the research assistants, teaching assistants, masters, PhD students, especially in the STEM fields, tend to be from Asia, many of them from India and other countries in Asia. And they don't want the universities to lose out on both the valuable talent and their research. So they've exempted F1s very cleverly because international students who come in, especially in the undergrad level, end up paying full tuition because you don't get in-state tuition benefits. So the government is basically ensuring that they get billions of dollars in tuition fees from people, from international students who are made to feel unwelcome in this country, a nation of immigrants.
But what happens if somebody in this OPT has got, fortunately or unfortunately, a H1 in the lottery for the period October 1 onwards? Then how does he or she handle it?
If you're in the United States, you would just file to switch your status, to change your status within the United States. It's called the COS, change of status, from F1 to H1B by filing the same thing what we talked earlier about filing it with the USCIS. On the other hand, if the person is abroad visiting family or friends, then they should actually plan to re-enter back before October 1st using the F1. And when the H1 petition is actually approved, let's say it's approved in September with an effective date of October 1, 2020, because that's when the USCIS fiscal year starts on October 1st of each year through September 30th of the following calendar year, then bingo, on October 1st, the person's status would change by operation of law, because the USCIS would have approved the person to change from F1 to H1B. But the person cannot have been traveling abroad when it was filed or when the petition is pending. So in this case, if the person's H1 petition was pending, you now have a problem because they probably filed under the H1 quota of the lottery. And if they're abroad at that time, then the USCIS cannot approve the change of status because by, again, operation of law, a change of status is deemed abandoned upon departure from the United States.
Okay, so he or she should have traveled after the H1 was approved for pendency in October 1st, 2020, but still having a valid F and come back on that valid F and then change status while in the US.
Absolutely. You hit the nail on the head. Perfect. Yes.
So how's the technology sector, especially the R&D industry, responding to this?
Well, I mean, look, the day Trump came into office, from the very first day, he's been raving and ranting, not raving. I wish he was raving about immigrants and their contributions to America. He's been ranting about how he's going to go after immigrants and, do all of this. In fact, there was a letter written by, I think, 350 or 300 of the top major technology companies in the United States to the director of the Department of Homeland Security, U.S. Department of Homeland Security, to DHS, saying, look, guys, what you're doing is actually really going to actually hurt the economy and make things worse for us and make things bad. And we are no longer going to be able to be the technological leader in the world if you continue this assault against H-1B extensions and approvals and L1s and all of that. But it's almost falling on deaf ears. So the companies are miserable. The universities are upset. Everybody's seeing the impact of these anti-immigrant policies, which seem to be more almost racist rather than purely objectively anti-immigrant. When you hear the president passing comments like, gee, why can't we get people from Finland and Sweden, from those fabulous countries, Finland and Sweden, rather than from those, countries like in Africa? And so it sort of, I think, reinforces the concerns that we're dealing with xenophobia as opposed to truly rational, legitimate reasons for protecting Americans and American jobs. It's catering to the middle America, which to a large extent, unfortunately, hasn't jumped on the knowledge economy bandwagon and tends to still sort of almost clutch the manufacturing types of jobs and other jobs which don't require a degree or college education. And those have been the most impacted by generally the changes in technology over the past quarter of a century.
It's interesting you also, and it's a good segue into the university, because as it is, there are so many students aspiring for foreign universities, especially the US universities. And the two big issues or the two big charms, one, of course, is the classroom experience, and other is the dorm experience. And in a situation like this with the pandemic, when classes are online and the dorm is your bedroom at home, both those huge learning crucibles are really not available for students. So there is a big challenge, as it is the education university in the US especially is facing. And add to that this woes, if they are not able to get the H1, then it makes it even more difficult, isn't it?
Absolutely. I agree 100% that the best part of the US education is the ability to interact, those informal, casual bump-ins when you stop somebody and talk about issues, discuss, analyze, solve a problem in groups, which you may hesitate to, schedule a Zoom call, or schedule a phone call or pick up the phone because you feel you're interrupting somebody. When you bump into someone walking along in a corridor, chatting about it in classroom study group discussions. I mean, the US education, there's a reason it's number one in the world. Out of the top 100 universities in the world, I think more than 90% are all based in the United States. And unfortunately, even our IITs don't fare within that top 100 list. And so you have these fabulous centers of true learning and intellectual ecstasy that exists with your colleagues and classmates. And all of that is now no longer an option because of COVID-19, because of the restrictions, the social physical distancing required, etc. And many of the universities have decided, including Harvard, that they're not going to have classes this coming fall. And I don't know why. I remember myself, 35 years ago, spending those days $22,000. Now I understand it's $75,000 each year to study at Harvard Law School. And if you have to spend that kind of money, $75,000, and you're not going to meet anybody, talk to anybody, I appreciate and understand the nuances of the culture, it's a very instinctive, it's almost a gut understanding of the culture when you interact in person, as opposed to reading a book and understanding the theory of how, an American mind may think or respond to the world. And so I don't know that I would think it's a good investment of my time or money, just studying remotely or online classes. And how can the universities justify charging those outrageous fees to basically provide an online education that a lot of which is available for free?
And then the double whammy of the Damocles sword of the potential immigration threat.
Absolutely. Now you finish graduating after spending $75,000 each year on this fancy Ivy League education and, several hundreds of thousands of dollars in debt per child as parents. And now you're saying, you know what? We're not even welcome. They don't even want to give us jobs. And they've even talked about in the same executive presidential proclamation, they've talked about further looking into addressing concerns that they have with the F1 STEM and with the OPT program itself. So you're talking a sword that's hanging there, and it's coming closer and closer to you, because now they're saying we don't know if they want to eliminate it or restrict it further. But of course, this president has seen multiple lawsuits from the first week that he got into office, challenging all of his executive orders, because pretty much most of them actually violate the U.S. Constitution and their Administrative Procedures Act, or APA, their own regulations in most cases. So that's why most of these cases, the people who are suing them, whether it's the American Civil Liberties Unions or law firms like ourselves, the Murthy Law Firm, we've been suing the government left and right. And that's one of the great things about America. I know most Indians sort of hesitate, especially Indian-owned companies, technology companies say to me, we don't want to sue. No. It's a very Indian Desi mentality, because we grew up thinking, oh my God, you don't go against the central government or the federal government, because we would have to continue to stay in business after that and they might come after us. But the truth is, in America, it is the opposite. The government attorneys, many of whom we know personally, because, there's respect for each other, because that they're doing their job and they know we are doing our job in fighting and representing our clients, that everything we're doing ultimately is going to benefit America and our clients. In fact, one of the major technology consortiums with over 1,000 technology companies called the IT Serve Alliance. I am their legal advisor for IT Serve Alliance, one of their pro bono legal advisors, their main and for 5 years, I have been, even before Trump became the president, I had been impressing upon them the importance of freely being able to challenge the federal government if they break the law or violate the law or exceed the boundaries within the framework of the US Constitution. And I remember they would look at me wide-eyed, would determine that here's this crazy person, ranting, we're just going to ignore her. And guess what? They have become one of the biggest embracers in the last 3 years when they saw one by one the H-1 petitions denied, the RFEs, the onslaught of the RFEs. Their businesses were pretty much going to have to shut down if they did not challenge the government. And now, because they've challenged it, all the other major large companies are now actually able to take advantage of getting fewer RFEs and fewer assaults and larger and extensions for the full 3 years instead of 6 months or 3 3-month H1 extensions for consulting companies, thanks to the IT Serve Alliance, finally, and they said that to me even last evening when I was talking to the president of the organization, he made it clear. He said, Sheela, if you hadn't gone and really, really told us the importance of challenging the federal government in the United States, we had absolutely no clue that this is how the federal government works, that this is how it works in the United States. And so I think that's the greatness of America as well, is the ability to challenge the government, and not only don't hold it against you, they actually respect you more because they know that you're not somebody that can be walked all over and treated with disrespect, and you're going to be quiet when your rights are being transgressed upon.
I know this RFEs, or the request for evidence, right? Request for evidence that the H1s and the L1s sometimes have is such a, the landscape is littered with the RFEs, right? And I'm so glad that you have taken that approach, Sheela. So what is the legal landscape looking like against this Trump order?
I think the legal landscape itself within the United States for people who are here hasn't changed dramatically, but it certainly gives people the impression, understandably and rightfully so, that we are not welcome. We are treated like we are second-class citizens because we're on an H-1B or an L-1 or what have you. Unless you're a U.S. citizen, you're somehow second-class in some way, which is really harmful and bad because this economy and this country, the United States, needs the talent, the value, the skill that is much needed and in short supply in the United States. There's so much research that is done which shows that every H-1B worker helps to create 2 jobs for American workers. These are independent think tanks that have provided neutral research. And it's just a shame that this has become almost like a game as opposed to looking at the reality, looking at the statistics, looking at the numbers and saying, you know what, let's embrace those who contribute to the greatness of America, and let's welcome them with open arms so that they and their families can get enriched, and so can the country in the process of keeping this incredible talent within our shores.
So have many lawsuits been filed against this order?
Well, this order, it's too early, but yes, people have started preparing for it. We already know several organizations that are working towards it. We know on the travel ban when he did it, it was within the few days because people were on flights midway arriving in America when they were impacted. Here, he gave 2 days time, so there was nobody en route on a flight about to land in the United States in half an hour after a 14-hour flight that was being turned back and told take a deportation or leave. So those lawsuits had to be filed within 1 or 2 days. This, we have a few days, and I know that several organizations have already talked about how and different approaches and angles to sue them. Obviously, it's been less than, it's just over a week at this point when we're recording or, having this discussion. But several organizations are absolutely looking at the different angles on how to approach and how to challenge the government to either roll it back or restrict it, because it is certainly exceeding the powers and the very reason for why the proclamation was passed.
And finally, Sheela, a little bit of crystal ball gazing. What do you think will happen to the executive order if Trump A, loses, B, if Trump wins?
So if Trump loses, we believe that Joe Biden, even though he's not come out as clearly, I wish he was far clearer, he has suggested that what Trump is doing is clearly, breach of the law, etc. He's probably going to roll back many of the immigration decisions and orders and bans and restrictions imposed by the Trump administration, similar to what Trump tried to do by trying to reverse almost everything that President Barack Obama had instituted, more to make a point, I think, than really believing that they were bad for America. So if he loses, I think we're going to, hopefully, that's the dream and the hope, that things will pretty much come back. They still will be going after those who break the law or come in illegally and, enter illegally and stay and work without authorization, because the FDNS and the ICE, the Immigration and Customs Enforcement and Fraud Detection and National Security, will continue their work because their budgets have continued to increase, unfortunately, and they've taken money away from processing cases to hiring more agents. But if Trump actually wins, I think it's another 4 years of hell on earth, because I think what we've seen in the first 4 years is only a preliminary taste of the incredible monstrosities that can be unleashed, because now you have nothing to lose in the next 4 years, because you don't have another election that you can stand to, that you can stand for, you need to prove, and you feel vindicated to a large extent that, hey, the American population agrees with me that we need to go after immigrants in a bigger way. We're very hopeful that our country will come back to sanity and civilization. But we've seen strange things happen, and unfortunately, neither you nor I, Hema, have the magic crystal ball to know for sure.
Yeah. And, just a few minutes ago, I think NDTV had a breaking news which said Joe Biden says he will revoke the H-1B visa suspension if elected US president, kind of reinforcing what you were saying just now, Sheela.
Exactly. He's been very critical of almost everything with the Affordable Care Act, the immigration bans. He's made it pretty clear that he is absolutely going to roll back a lot of these very destructive policies that will actually harm Americans and the American economy.
Thank you, Sheela. It must be the start of a very, very busy day for you. Thank you so much for taking time to talk to us on the whole immigration landscape in US.
It's a pleasure. It's an honor. Thank you for the opportunity. Good luck to you and good luck to all in your audience as you try to navigate these complex and ever-changing rules, regulations, and policies.
Thank you for listening in till the end. Please share this episode with a friend on social media, WhatsApp, or anywhere else. It would mean the world to us. And in case you're listening via iTunes or Apple Podcasts, please leave us a rating and a review. Subscribe to BIC Talks on email or your favorite podcast app and don't miss out on future episodes. This episode of BIC Talks has Gaurav Krishna as our sound engineer with support from S. Sarvanaraj and Lekha Naidu. And the accompanying episode artwork was made by Chandni Venkataraman.
Thank you for listening to this episode of BIC Talks. This podcast can be accessed on our website, bangaloreinternationalcenter.org, as well as on any of your favorite podcast platforms. Tune in for new episodes every week, and do subscribe to our YouTube channel and follow our Facebook, Twitter, and Instagram pages to stay informed on our latest updates.